So a pleasant morning, everyone. We are the group 8, and we will discuss the module 8, which is separation and termination of employment in the Philippines. Next po. Next. Sige pa, next pa po. Sige. For my part, I will discuss the dismissal and termination. Okay. So what's separation and termination of the employment in the Philippines? Pabalik ako, yan. A separated employee is one who leave an employment situation for any reason, whether voluntary or involuntary. A terminated employee is involuntarily let go, or usually because of poor performance or lack of work. So sa separated employee, ito yung usually na mga gustong sila yung mismong nag-leave, hindi yung nagbo-voluntarily silang nag-leave, umalis sa kumpanya na yon. And yung sa terminated employee naman, which is ito naman yung may mga bad record, kaya nagkakaroon sila sa isang company ng pag-terminate for the employee. So, yeah. Sa Labor Code of the Philippines is a legal code that determines all employment practices and labor relation in the Philippines. This is to help protect employees and employers while ensuring that neither is subject to unfair treatment or exploitation. Ito yung legal code na lahat ng mga employees ay makakatanggap ng good treatment galing sa kanilang kumpanya para na din sa buong pagtatrabaho nila sa isang kumpanya na 'yon. So next, dismissal of unemployment in the Philippines. The dismissal of unemployment in the Philippines is a sensitive stage and can only be implemented by a just or authorized cause as defined under the Labor Code. Trial periods and fixed-term contracts can be determined without difficulty, whereas open-ended contract are subject to increased protection. So, sa part na to, I will discuss the termination by employment. So, ano nga ba ang termination by employment? What happens when an employee is terminated? For example, the question, employees terminated or fired by an employer have intern rights. An employer has the right to receive a final paycheck or payback and the option of continuing health insurance coverage, and may even be eligible for severance pay and unemployment compensation benefits. And for the voluntary resignation, for another explanation, it refers to the situation where an employee decides to terminate his contract or service with the company. And for next po. Yon. So, yung two types of employment termination in the Philippines. So, yun nga, yung termination by employer and voluntarily resignation or terminated by employee. The employers can dismiss an employee based on just an authorized cause. And second, voluntary resignation is defined as a voluntary act committed by employees who knowingly dissuaded themselves from their employment for personal reason. So, next po. Termination by employer. According to Article 282 of the Labor Code, an employment can terminate an employee for just causes, which could be any of the following. First, serious misconduct or willful disobedience by the employee of the lawful orders of his employer or responsive in connection with his work. Second, gross and habitual neglect by the employee of his duties. Third, fraud or willful breach of by the employee of the trust reposed in him by his employer or duly authorized representative. Fourth, commission of a crime or offense by the employee against the person of his employer or any immediate member or of his family or his duly authorized representative and other similar causes. So pa next po. Employers can also terminate an employee based on unauthorized cause like business and health reasons. From Article 283 of the Labor Code states that an employee can be terminated due to business reasons such as installation of labor saving device. For this installation of labor saving device, it says that dun muna tayo sa redundancy. From the word redundancy is a form of dismissal from your job. It happens when employers need to reduce their works. And next, retrenchment, reduction of cost to prevent losses. From the word retrenchment, retrench employee means an employee whose employment has been terminated by the company by reason of its being surplus to the requirements of the company. And for the last, the closing or cessation of operation. This cessation of business operation is one of the authorized costs which may be involved by the employer in the terminating the employment of its employees, even without fault on the part of the latter. Severance pay with termination. An employee is entitled to separation pay equivalent to 1 month pay or at least 1 month pay for every year of service, whichever is higher. A fraction of at least 6 months shall be considered as a whole year. The period of service is deemed to have lasted up to the time of closure of the establishment. So from the word severance pay, it's a paid to employees after they have been fired or severage from their job. It's usually given increase where a person is fired due to downsing or job elimination rather than a voluntary job termination. So pa next po. There are several key features to be on the lookout for. First, lump sum or formula base. This lump sum is amount of money that paid at one time. For second, free and clear or conditional. It could be as simple as receiving a separation or severance offer at all. Also, it could be a check and thank you for your service, or it could be a request for an employee to assign an agreement. And one time or spread out. This one time or spread out, its separation pay is generally offered as a lump sum or one-time payment, but some companies option to spread out payments over time. And for the last, additional service. For additional service, the company may also provide career opportunities in addition to monitor compensation. Separated employees may receive counseling, or job placement aid. So that's my part. For the next reporter, please. Thank you.
So next is the difference between a just and authorized cause of termination. So a just causes are based on acts attributable to an employee's own wrongful actions or negligence, while authorized causes refer to lawful grounds for termination which do not arise from fault or negligence of the employee. So a just cause termination means that the employer has terminated your employment on the basis of serious misconduct that goes to the heart of your employment contract. A just cause termination means that the misconduct was severe enough such that your employment relationship cannot be repaired. So employers have the right to terminate employees but must give notice that the employment is ending. An exemption to the notice requirement applies where the employer can prove just cause. Just cause refers to conduct that is of such a serious nature of extent that it essentially breaks the employment relationship. Employment Standard investigates complaints to determine if the employer had just cause for the termination. So, what are considered just cause for termination? So, according to Article 282 of the Philippines Labor Code, the following just causes by the employee can be the basis for firing an employee in the Philippines. Just causes of termination refer to serious misconduct, willful disobedience or insubordination, gross and habitual neglect of duties, fraud or willful breach of trust, loss of confidence, commission of crimes or offense, and analogs causes. So next is Article 284 Labor Code. In Article 284 Labor Code, if your employee suffer from a health condition that lasts more than 6 months or the law prohibits them from working such as disease or working in harmful to themselves or the other co-workers, you are entitled to terminate their contract. The second type of employee termination is when the employee decides to resign. According to Article 285 of the Labor Code, employees in the Philippines can quit their jobs either with or without a just cause. Without a cause, an employee needs to hand in a letter of resignation with a 1 month notice. If he or she fails to submit a notification, the employer can charge him/her for any concurrent damages. For example, for the amount of work he/she fails to deliver due, the, due to their untimely resignation. So next is authorized cause of termination. Authorized causes of termination refer to installation of labor-saving devices, redundancy, retrenchment, or downsizing, closure or citation of operation and disease. For authorized causes, the employer is required to inform DOLE and the employee. So what is the difference between a just cause of termination and an authorized cause of termination? Just like what I said earlier, a just cause termination means that the employer has terminated your employment on the basis of serious misconducts that goes to the heart of your employment contract. A just cause termination means that the misconduct was severe enough such as employment relationship cannot be repaired, while authorized causes of termination refers to installation of labor savings devices, redundancy, retrenchment, or downsizing, closure or cessations of operation and disease. So that's the end of my part.
Pabalik po. Pabalik po. Yung isa. So, next is causes for termination by the employer. According to Article 282 of the Labor Code, an employer can terminate an employee for just causes, which could be any of the following. So, ito yung mga causes or an act attributable to the employee which result in his termination. First is serious misconduct or willful disobedience by the employee of the lawful orders of his employer or representative in connection with his work. So ito yung mga inappropriate behavior that willfully committed by the employee, katulad ng pagnanakaw or theft, fraud, assault, discriminatory conduct, harassment, being intoxicated at work, refusing to carry out lawful and reasonable instruction that is consistent with the employee's contract of employment. Next is gross and habitual neglect by the employee of his duties. So gross and habitual neglect of duties implies a repeated failure to perform one's duties. Normally, isolated act of negligence do not count as a cause for termination. A single act of negligence which is grossly damaging to the employer may qualify as a cause for terminating the employee. So dito, ito yung pagpapabaya o paulit-ulit na pag-abandona ng employee sa kanyang duty sa trabaho. Katulad ng hindi pagpasok on time, palaging late, madalas absent, or hindi niya nagagawa ng maayos yung trabaho niya as an employee na nagiging habit niya na and nag-cause ng pag-terminate niya sa kanya ng employer. Next is fraud or willful breach by the employee of the trust reposed in him by his employer or duly authorized representative. So ito naman yung pang-aabuso sa tiwala ng employer sa employee. Loss of confidence as a just cause for termination of employment is premised on the fact that the employee concerned holds a position of responsibility, trust, and confidence, or that the employee concerned is entrusted with confidence with respect to delicate matters such as handling or care and protection of the property and assets of the employer. The betrayal of his trust is the essence of the offense for which an employee is penalized. Next is commission of a crime or offense by the employee against the person of his employer or any immediate member of his family or his duly authorized representatives. So, yung commission of a crime or offense as a just cause for terminating employees is limited to those which are committed against the employer or any member of his immediate family. So yung immediate family includes the spouse, ascendants, descendants, legitimate, natural or adopted sibling of the employer. Also included are the relatives of the employer by affinity in the same degrees and those by consanguinity within the fourth civil degree. Next slide, please. So, just causes for termination by the employee. This type of termination is strengthened by the provision of Article 285 of the Labor Code. It indicates the just causes for resignation as follows. So, ito naman yung mga causes of voluntarily resignation of an employee. First is serious insult to the honor and person of the employee. So, serious insult to the honor and person of the employee. So one of the reasons why employees leave their company is their boss. The common experience of employees may have with their bosses is insulting in the context of performance or work-related issues. An insult from boss may not be personal but performance-related and may not be direct but sometimes below the belt. The intention is to call your attention, steer emotion, and get the message across. Next is inhuman and unbearable treatment accorded the employee by the employer or his representative. So ito naman yung hindi tamang pagtrato ng employer sa employee katulad ng physically, verbally, mentally, and emotional abuse na paulit-ulit na ginagawa ng employer na nagiging dahilan ng pag-alis nito o pagre-resign. Next is crime committed against the person of the employee or any immediate members of the employee's family. So for a resignation to be valid on the ground of commission of a crime or offense, first is there must be an act of omission punishable prohibited by law. Second is the act of commission was committed by the employee or any immediate member of the employee's family and other similar causes.
Authorized causes for termination. For authorized causes, the employer is required to inform DOLE and the employee that, for example, his position has become redundant at least 30 days before the intended date of termination. So, to be clarified, just causes of termination refer to serious misconduct, willful disobedience, or insubordination, gross and habitual neglect of duties, fraud of field for breach of trust, loss of confidence, commission of crime or offense, and analogous causes. The rules expressly provides that for act or omission to be considered as analogous causes. At the same time, it must be expressly specified in company rules and regulation of policies. So, termination. So, pag sinabing nating termination, of course, for the example is for the company. Of course, that company has rules and we must be able to follow that rules. So, kapag halimbawa tayo employer, so kailangan natin sundin yung mga rules na or mga batas ng isang company to be able na hindi tayo maging ma-terminate. So, in addition, authorized causes of termination refer to installation of labor-saving devices, redundancy, retrenchment of downsizing, closure and cessation of operation, and disease. And it also clarifies that employee may also be terminated from employment based on the reasonable and lawful ground specified in the company and also based on the ground provided by the under collective bargaining agreement. So syempre, hindi naman terminate kaagad. May mga batas sila, may mga rules sila, may mga steps sila paano ka ma-terminate, and of course, it is reasonable. So next slide. Due process in the context of termination of employment. So it is the context of employment. Termination is the right of an employee to be notified on the reason for his or her dismissal, and in case of just causes, to provide the opportunity to defend himself or herself. So first of all, what is the difference between the dismissal based on just cause and the dismissal based on authorized? The dismissal based on cause means that the employee has committed a wrongful act or omission. So that dismissal is yun yung nakagawa ka ng kasalanan talaga, ikaw talaga mismo yung gumawa ng kasalanan. While the dismissal based on the authorized, it is that there exists a ground while the law of itself authorized to be invoked to justify the termination of an employee even if he has not committed any wrongful. So, ito naman, parang napagbintangan ka lang and na-terminate ka. And also, it is a process. It different for both authorized and just cause. Just cause involved 2 notice rule, while authorized cause is required 30 days notice. So, Based on R279 Labor Code, if due process is not accorded to the employee before termination of the employment or the termination itself, it's declared illegal, the employee is entitled to receive restatement and full back wage. So, this is the first rule na kailangan gawin pag na-terminate. They written notice, commonly referred to a notice, explain, specify the grounds for termination and giving the employee ample opportunity to explain their side. Of course, bibigyan naman tayo ng opportunity na mag-explain ng side natin, mag-explain ano ba talaga yung nangyari. Ano ba talaga yung paglabag sa company, sa rules ng company na nagawa natin. And the second one is hearing or conference to allow the employee to respond to charge, present evidence, or rebut the evidence presented against them. So ito naman yung ilalabas nila lahat ng evidence mo or ng mga tao na nasa paligid mo na magsisilbing evidence kung ano ba talaga yung ginawa mo, magpapatunay na nakagawa ka ng isang pagkakamali. And the third one is a notice of decision indicating the justification for termination as well as the corresponding section or if any after due consideration of all evidence. So ito na yung final judge ng HR ng isang company kung mati-terminate ka ba o hindi. And this is the final submission of written notice of dismissal to employee specifying the grounds for dismissal of at least 30 days before the date of termination, and also a copy of notice while shall be provided the regional office of the Department of Labor and Employment or DOLE where the employer is located. So next reporter po.
So I will be reporting the Labor Code of the Philippines, Book 6, Post-Employment, and the Termination of Employment. So the Labor Code of the Philippines stands as the law governing employment practices and labor relations in the Philippines. It was enacted on Labor Day of 1974 by President Ferdinand Marcos in the exercise of his then extended legislative powers. It prescribes the rules for hiring and termination of private employees, the condition of work including maximum work hours and overtime, employee benefits such as holiday pay, 13-month pay, and retirement pay, and the guidelines in the organization and membership in labor unions as well as in collective bargaining. The Labor Code contains several provisions which are beneficial to labor. It forbids termination from employment of private employees except for just or authorized causes as prescribed in Article 282 and 284 of the Code. The right trade or union is expressly recognized as the right of a union to insist on a closed shop. So, termination of employment, Article 287, coverage. The provisions of this title shall apply to all establishment or undertakings whether for profit or not. So this law, kailangan siyang ipatupad sa mga company or a business para na rin dun sa benefits ng employee and employers. Article 279, security or tenure. In cases of regular employment, the employer shall not terminate the services of an employee for a just cause or when authorized by this title. So kapag yung isang employee ay tinanggal sa kanyang trabaho na walang valid reason, pwede itong makabalik or maibalik sa trabaho nang hindi nababawasan or nawawala yung mga privilege niya, allowances, or ibang benepisyo. Article 280, regular and cause employment. An employment shall deem to be regular where the employee has been engaged to perform activities which are usually necessary or desirable in the usual business or trade of the employer. So yung employee is pwede siyang maging regular or pag yung mga pag yung paggawa niya is pag maganda yung pagkakatrabaho niya sa isang company or business. Next, please. Pinig ba ako? Article 281. Probationary employment shall not exceed 6 months from the date the employee started working unless it is covered by an apprenticeship agreement stimulating a longer period. So dito, the employee can be terminated within 6 months in a company unless there is a contract. So pwede pa siyang pwede siyang ma-terminate within 6 months, pero if there is a contract na pwede pa siya mag-exceed, hindi pwede yon. Article 282, Termination by Employer. An employer may terminate an employment for any of the following causes: serious misconduct or willful disobedience by the employee of the lawful orders of his employer or representative in connection with his work; gross habitual neglect by the employee of his duties; fraud or willful breach by the employee of the trust reposed in him by his employer or duly authorized representative; commission of a crime or offense by the employee against the person of his employer or any immediate member of his family or his duly authorized representatives; and other causes analogs of the foregoing. Next po. Article 283, Closure, Establishment, and Reduction of Personnel. So dito, hindi pwedeng matanggal yung isang employee maliban na lang kung yung pinagtatrabahuhan niya or establishment niya is nagsara due to serious business losses, for example, is bankrupt, or yung kailangan talagang magbawas ng personnel sa business na yon. Article 284, Disease as ground for termination. The employee can be terminated pag meron tong serious illness or disease kasi 'di ba isa yun sa requirements ng mga business or company yung health nila, health ng isang employee para na din dun sa employee at saka sa co-employers niya. Article 285, Termination by Employee. An employee may terminate without just cause the employee-employer relationship by serving written notice on the employer at least 1 month in advance. The employer upon whom no such notice was served may hold the employee liable for damages. An employee may put an end to the relationship without serving any notice on the employer for any of the following just causes. Next po. Serious insult by the employer or his representative on the honor and person of employee. Inhuman and unbearable treatment accorded the employee by the employer or his representative. Commission of a crime or offense by the employer or his representative against the person of the employee or any of the immediate members of his family, and other causes analogs to any of the foregoing. Article 286, when employment not deemed terminated. The bona fide suspension of the operation of a business or undertaking for a period not exceeding in 6 months or fulfillment by the employee of a military or civic duty shall not terminate employment. For example, while you were working and at the same time you need to fulfill a military or civic duty, pero hindi siya lalagpas ng 6 months, the employee shall not be terminated. That's all. Next reporter, please.
Hello. So my report is the Title 2 or the retirement from the service under the Labor Code of the Philippines, Book 6. So a regular step of the service lifetime is retirement. Simply put, it signifies you won't be providing the service anymore. The way you design and execute your service retirement may have a significant influence on the organization's reputation. Clients who have used and relied on a service for a long time may find it difficult to let it go. Careful service retirement planning, which includes a client-focused communication strategy, will go a long way toward alleviating their fears. So according to Labor Code Article 287, which is about retirement, any employee may be retired upon reaching the retirement age established in the collective bargaining agreement or other applicable employment contract. The employee shall be entitled to receive such retirement benefits as he may have earned under existing laws and any collective bargaining agreement and other agreements such as that an employee's retirement benefits under any collective bargaining and other agreements shall not be less than those provided therein. If your firm provides a specific retirement plan for its employees, consider yourself one of the fortunate few because firms are only required by law to provide a retirement plan, but not all companies do so. So a firm is the difference between a firm and a company is a firm is a business that makes money by selling services and products, mainly by professional services, while a company, on the other hand, is a business that engage in any revenue generating activity that involves the selling or of products and services, and it encompasses all commercial trades and structures. Retirement compensation is determined by a person's work history and performance and is supported by their employer. Next slide, please. In the absence of a retirement plan or agreement providing for retirement benefits of employees in the establishments, the Retirement Pay Law or Republic Act 7641 allows departing workers to a retirement pay equivalent to at least 1/2 month's wage for each year of service, with a portion of at least 6 months being deemed a full year. A half-month wage consists of 15 days plus 1/12 of their 13th month pay and the monetary equivalent of not more than 5 days service incentive leaves. And an employee must have worked for the firm for at least 5 years before attaining the age of 60. A retirement plan, on the other hand, might be supplied by a company or set up by an individual. In most cases, retirement plans allow employees to contribute to a fund that is matched by the company. This money is subsequently put into a variety of investment vehicles. The retirement plan, unlike the retirement salary, does not guarantee a set sum of benefits when you retire. So how much can we get from our retirement pay? So it is an important question to ask. Like, am I entitled to a retirement pay? There are various exemptions to the retirement pay law. Employees, next slide please. So employees in retail, service, and agriculture businesses are not covered. Companies with less than 10 workers are likewise exempt from the provisions of the statute. Furthermore, under Republic Act 7742, an employer may consider the Pag-ibig Fund as replacement retirement benefit for its employees if they contributed to the fund. Assume you earn 20,000 pesos per month, which is the maximum monthly salary credit, and you are eligible for a retirement payment. How much will you get when you retire if you've been with your employer since you were 20 years old and will retire when you're 60 years old? So the formula is the minimum retirement pay, which is 600,300 pesos, is equal to daily rate, which is 667 times 22.5 times the number of years in service, which is, let's say, 40 years. Getting about 500,000 pesos sounds good enough. Aside from your retirement pay, you may also get government benefits such as your Social Security system or the SSS pension. Next, violation of this provision is hereby declared unlawful and subject to the penal provisions under Article 288 of this code. So the goal is to have a comfortable retirement where you don't have to worry too much about where to get the resources you need. Relying solely on your company's retirement pay or government benefits, such as your SSS pension, may help you get by with a little scrimping, but the goal is to have a comfortable retirement where you don't have to worry too much about where to get the resources you need. Planning ahead and taking the required actions to develop and safeguard your money are the greatest ways to reach your retirement goals. Aside from saving, one option to guarantee your financial future is to get an investment-linked life insurance policy. You put in enough time and effort. Now it's time to put your money to work for you. That's all.